we're having a little bit of technical difficulty, but you can look here to see what's going on. This is Crystal Magee. She's going to tell us about obtaining ethically records from the agency, which is important for anyone who handles any kind of child abuse types of cases or other cases where these CPS records are implicated. So without further ado, here's Crystal Magee, a regional attorney for Child Protective Services. Thank you so much.
Thank you. Thank you. Good afternoon. Again, my name is Crystal Magee. I'm one of the 7 regional attorneys here in Region 6, and I would like to take a few minutes to just kind of let you know the organization of CPS and about the regional department and our duties. So, the department has divided the state and the counties into 11 regions. Harris County happens to be in Region 6. That's a very small map, but Region 6 is comprised of 13 counties, as north as Walker County, as south as Galveston, as west as Colorado, and as east as Liberty and Chambers County. Part of the duties of the regional legal department, we do represent CPS in some of the termination cases, removals in some of the smaller counties. Obviously, you know, here in Harris County, the county attorney's office represents CPS in most of their cases. And just a quick survey, has anybody ever subpoenaed CPS records? Okay. Okay. Good experience? No. Okay. Okay. Hopefully today I could help make better experiences for you guys. So one of the duties that we do have is to ensure the compliance of all the subpoenas that are served in our region. So for every case in our region, when a subpoena is served, it has to be reviewed by our department. Of course, that's not including cases in which CPS is a party, but it is including all of your criminal cases. Is that better? Okay. So any private family cases, divorces, any child custody issues, anytime anybody wants CPS records, it has to come through our department. So some of you might be wondering, what is the big deal? Why can't I serve a caseworker 4:30 the day before the hearing and ask for records to be produced the next day at 8 o'clock? What's the big deal? What's wrong with that? Some might assume that the caseworker would receive a subpoena, be able to go to their office, go to their computer, pull up the case, and press print and bring the records to court. Do any of you think it's as simple? Okay, good. Well, good. And the reason it's not, obviously the Family Code has defined our records as confidential, and they are not subject to public release as other public information as provided in the Government Code. In fact, the Government Code makes it a crime for us to release this confidential information other than in a way that's provided by the law. So it's a really big deal, and we do take the confidentiality of our records very seriously. And let me just step back again to say the Department of Family and Protective Services is the umbrella that is over Child Protective Services and Adult Protective Services. So I may use those names interchangeably, but CPS, APS, department, all the same thing. So it might help for me to walk you through the process of a subpoena and how it flows once it's served on the caseworker. The first thing that you guys may want to know, who do you serve? If you want CPS records, if you want a caseworker to come testify at your hearing. If you know the caseworker, and you can name that worker in your subpoena, or you can just address the subpoena to the custodian of records. And if you're still drawing a blank and you have no idea how to or who to determine who to serve your subpoena on, I will give you the contact number for our records management department And their customer support line is set up just for that. You guys can call and find out who to serve and where to serve. Okay. The next question is how? How do you serve a subpoena on CPS? We obviously do accept all methods of service under 24.04 of the Code of Criminal Procedure. But just to give you guys a note, those of you who do practice family law as well, we do require personal service for all civil subpoenas. For all civil subpoenas. Civil, yes. Criminal, it's pretty wide range that we accept. When should you serve a subpoena on CPS? Please, 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 not the day before. And I'll explain why that can't happen. But we do require at least 14, well, we ask for 14 business days before the records are due. In fact, if the records department receives a subpoena less than 10 business days to process, they're going to send it back to me and say, hey, we can't do this. And they're going to leave it to me to handle and possibly file a motion to quash. So, once the caseworker receives a subpoena, they are trained to immediately forward that subpoena to the legal department for our review. At that time, we review the subpoena to make sure that, one, that it has been served properly and that it does meet the requirements of a valid subpoena. Obviously, if it does not meet those requirements, again, I may be forced to file a motion to quash the subpoena. But if it does, then at that point, we do forward the subpoena on to our records department at that time. Even then, it's subject to another review by the records department to make sure that it's received in a way that at least they can comply with it. Sometimes they'll send one back on the basis that the subpoena doesn't specifically state what records are being requested. So they'll send that back to me for me to contact you guys to either modify the subpoena or give them some clarification. Just a little bit about our records management department. They do service the whole state. It's not that we have one just for our region. They service the whole state for subpoenas, record requests, discovery requests. Anything that's not a subpoena or a court order, at this time, they're backlogged for up to a year for people to expect their records. So that's just how busy they are. So a little bit about their process. Once it's received and reviewed, the customer support office will assign the case to a redaction specialist. That specialist will then start to gather the records, and that can be a very detailed process depending on the amount of records and the age of the case. So the first part, they will gather our system-generated records. If any of you have ever dealt with CPS before, you know that we have a software called Impact in which the caseworkers keep their notes, their reports, their narratives. Obviously, those things are pretty easy for them to access. They're right there in the system. Like I said, anything that's generated by the caseworker. But of course, during the course of a CPS case, a caseworker may receive a lot of other information. Examples would be drug test results, psychological examinations, and things of that nature. Those are not made a part of their file in Impact. They're just made a part of their paper file. And so once a caseworker closes a CPS case, they are not allowed to just keep their file in their filing cabinet in their office. They have to send it off to be stored and maintained by another division of our records department, is the Records and Imaging Office. So those external files are sent to them and maintained by them. So the records department has to contact them to get those records when they're in their gathering process. So once they've gathered all of the records, that's when they will start their entitlement review. Now, the Texas Administrative Code, Section 700.203, has outlined the individuals and entities who are entitled to receive our records. And just to name a few, they are law enforcement officials, prosecuting attorneys, the grand jury, the children's attorney ad litems, guardian ad litems, a parent, adoptive parent, or legal guardian of the child, or the alleged perpetrator. So if you do not fall into one of the categories outlined in section 700.203, then legally you are not entitled to receive any of the records. So at the point they found out whether or not you are a person or entity, then they will go and review the records for entitlement as far as the actual information that that person can receive. And that's when the redaction process starts. There are many provisions in the Texas Administrative Code that are guidelines for information that we have to take out of our records, even if you are one of those parties who can obtain the records. I've listed a few up there. They're very small, but one thing is the reporter. The identity of the reporter is always redacted from our records. That is the person who called in the report of child abuse or neglect, or of elder abuse or neglect. Not only is the name, address, phone numbers of that person taken out, but any gender-specific pronouns or any other facts in the case that will make it obvious who the reporter is, that's also going to be redacted from your records. Okay. Other things that's going to be taken out, obviously social security numbers, HIV/AIDS, status and test, polygraph exam reports, police reports and police witness statements, official criminal history sheets, adult or juvenile probation records, reports from other agencies such as food stamps or TANF, attorney-client privilege information, any photographs, and any other CPS or APS history that does not have anything to do with the requester. Also reports from the medical examiner. Specifically when it comes to audio recordings and photographs, they are always redacted as well. Copies can be released pursuant to a court order if you're not one of the categories of people who can obtain a copy, which would mostly be law enforcement and government officials. The exception to that rule, though, is the forensic interviews. Even by court order, we cannot be ordered to release a copy of the forensic interview as long as the prosecuting attorney has made it available to you for viewing. And that is the Code of Criminal Procedure 39.15 and the Texas Family Code 264.408. So you might be asking, after all of this is redacted, what can I receive? There still is a lot of information that we are able to release if you are one of those people who can receive the records. So obviously anything that's not redacted, you will be entitled to receive. Obviously also anything that is ordered by the court at that point. So what happens is if there's an entitlement issue, our records management department would then alert me to let me know that, hey, we've processed this subpoena, we've gathered the records, however, this person is either a party who is not entitled to anything, or this person is a party who can be entitled to partial part of the records, which means that they are in a category that they can receive it, but redactions have been made. So at that point, I would contact you guys. I would say, hey, one, you're not entitled to receive any of the records based on the review of our records department, and I'll make it available, myself available, to come to court for an in-camera inspection. So at that point, the judge can review the records and make a decision on whether or not we should release the records to you. The required findings at this hearing, the judge has to find that releasing the records is essential to the administration of justice, and releasing the records would not endanger the reporter or the child or anybody else involved in the investigation or who cares for the child. So what that looks like is, if we find that you're not entitled to everything that you're asking for, I will contact you and let you know. If you are entitled to something, I will email those records to you, allow you a chance to review those records and say, hey, if this is not sufficient, feel free to contact me and we can set a time to have an in-camera inspection before the judge. Does anybody have any questions about that? Because I know that's one of the major issues that we run into. No. Okay. Would like to add that there is a way to bypass the whole subpoena process under 261.201. You could directly file a motion to disclose the records without going through the subpoena process. The ethical way to do that, however, is to make sure that you do give notice to all interested parties and the department. We have been receiving orders from motions for disclosure that we were not notified of, and obviously anybody who those records pertain to are entitled to notice as well. So if you want to do that way, make sure that you are giving notice to the people that are required to have notice under the family code.
Who else would that be besides you?
Any interested party. So other than the parties to your case, obviously it's just going to be you and the DA in these cases, but if you know who your records on and you're able to notify that person, they're entitled to notice as well.
So we're supposed to tell the family, the child guardians, or?
Yes. It depends. I mean, obviously, the way that some people request records, you may not know how many people it's going to affect. But if you are aware, the code says you are supposed to notify any interested parties. So I would just say, do your due diligence. If you don't know who to serve or how to serve, but if you do, which some people do, you should. Yes, ma'am.
When you say notify them, you mean like getting the process server notify them, call them on phone to notify them, send email?
I would, because I've had to do it before as well. I just send a certified letter letting them know that a motion has been filed and the date and the time of the motion. Just notice of the hearing. Okay. Anybody else? Okay.
Why did you choose to do that instead of just serving a subpoena? Because it seems like it'd be so much easier to just serve a subpoena instead of certified mailing the alleged fathers or the grandparents or the foster parents or anybody else who might be involved for the schools.
No, because like I said, I'm not always involved with the motions that they file.
Why did you do it when you filed a motion?
Oh, I had to notify the parents. A lot of times it's a civil case, and that just because the subpoena was on me, for my in-camera inspection, I still had to make sure that the other parties were aware of it.
Are the DAs allowed, like with that court order, to turn over CPS records?
Are they allowed?
Like I'm wondering, when you talk about like getting an order signed to bypass the subpoena process, typically the DAs have the CPS record before we do. I mean, not always, but most of the time. And if we get an order signed by the judge saying to the DAs, turn it over, is that ethical? Is that proper?
Well, like I said, I'm not involved with that order for the DA's office to turn it over to y'all. Of course, you do know that the DAs are entitled to the entire file, unredacted records. I wouldn't be a part of that if the judge ordered the DA's office to turn the file over. So, yeah, I've never seen that.
When the DAs get the record or they request the record, are they supposed to give defense attorneys notice?
I don't think so. No, they're,
Considered interested parties?
I'm sorry?
Are we not considered interested parties?
Yeah, the interested party part comes in when there has to be an in-camera inspection, when the judge is going to order release of records to a party who is not entitled to them. The DA's office, as law enforcement officials, they are entitled to unredacted records. In fact, they don't even have to really issue a subpoena. There's a form for them to fill out that they can send directly to Records Management Department. And a lot of times I'm not included in that because there's not an entitlement issue. I'm only notified when there's an issue that may have to require a motion. So if the Records Department gathers records to release to the party and there's no entitlement issue, they send those records back to the caseworker for release, and I'm not involved in that process at all. Okay. So some tips to remember in obtaining these records. Number one, if you can narrow the scope of the records that you're requesting, that would be helpful. Just to give you an example, if you state, I need any and all records of John Doe, any and all CPS records of John Doe, and you may have in your mind about a recent investigation. However, John Doe may have some CPS history of his own from when he was a child. And so if the subpoena states that as it is, then we have to try to produce those records as well. So if there is an instance where you can narrow the scope, please do so, and it could, shorten the processing time as well. If there's a time range that you know of, or the particular investigation case, the case number, if you know that, if you can include that in your subpoena, that will help with the processing time. Again, number two, allow at least 14 days for processing. Like I explained, the process, the flow of how it goes from the caseworker to the legal department to the records department. Obviously, that may not always happen in the same day, so you want to give us a little time to make sure that our caseworkers have given us the subpoena and that it's made it to the records department with at least 10 business days for them to process.
What about emergency hearings on family court?
We do get those a lot. Sometimes we understand that you just can't give us that much time, and we just kind of do what we can. We could bring the records that we can. Sometimes I will just bring what we can gather from our impact system, unredacted. Even in those situations, though, I can't hand the records over to you, and I can only say, Judge, this is what we've been able to gather, and I can hand them over to the judge at that point for still an in-camera inspection, because even in emergency situations, we still can't release the records without the proper redactions. Okay. Tip number 3, include your email address on the subpoena. For several reasons. One, if we do get a subpoena where we don't have enough time to process, we'll try to contact you to see if there's any way that we can work out some type of agreement for an extension. A lot of times we'll say, well, can the caseworker just come and testify, and that we'll be able to send the records later once we've been able to do the whole process, the gathering and the entitlement review. Another reason it's good for you to include your email address is that if records come in and you are entitled to some records, like I said, I will email those records to you right away and give you an opportunity to review them, and then to let me know whether or not an in-camera inspection is needed. Okay, so please, please, please include your email address. If not, I'm going to have to find the time to call you. You have to find the time to answer to give me your email address. Tip number 4, I did want to give you guys the contact information for records management. Again, like I said, if you're in a situation and you're trying to find out who to serve a subpoena to and where to serve them, this is the number that you can call to get information for that. They'll identify the caseworker or the custodian of records and give you an address and phone number to contact them. And if you're really, 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 really desperate, You can contact me as well. No, seriously, I'm very open to any questions. This is my phone number and also my email address.
Just go back to the previous one.
Sure. I trust you guys won't abuse it.
By the way, guys, materials will be provided via email like it is every year. So don't stress about writing down too much, but caveat, we have to be able to read your email address that you've written down for us. Because if you can't read it, we can't send it to you. Yeah, Mark. Is that it? Thank you so much.
I'm sorry.
Any questions at all, Crystal? Okay. It looks like you get an extended break. I've already told you about